Oh, yeah. Here's something really weird. Let's say that you're one of the big winners. You have a nonprofit mutual benefit corporation that you've been managing, and you're on the good list, let's say in Los Angeles. You are presumably Prop D compliant, and you've got no weaknesses on that, and the government's all happy with you. Now, what's going to happen for that type of company is they can continue to operate as they are, as a nonprofit, till 2026. Um, but they'll have to stay nonprofit, as far as I can tell. Whereas someone who reads the rules, it says that you don't, there's no mention of the word nonprofit in any of the new rules. So, in fact, and it even allows for public traded companies. So it's a for profit thing they visualized. Yet, to be grandfathered in means that you were state licensable or city licensable, rather, which means that you're a nonprofit. So it should be that any and all of the companies that are the pre 2015 June companies that should be allowed to continue pending the new rules, they are all nonprofit and should be forced to operate as such and on into the future. Because if they take the benefits of the company for their own use, the managers are guilty of a fraud. You can't just take the assets of a nonprofit and say that that's now your property. So if there is a business opportunity that is owned by a nonprofit, that doesn't mean that that business opportunity can be exercised by an individual. Okay, finally, back in the Long Beach case, there was a moment when an attorney, Pappas, brought up federal preemption. And it was like bringing the dragon into the courtroom, because we don't like to mention federal preemption in medical marijuana because it suggests that the federal government can legitimately preempt. But in his case, he was bringing it up to try to challenge the lottery that was being used to decide who would be the winners and losers in the Long Beach case, Long Beach jurisdiction. But I think that the same thing is true here. That federal law says that you have a privilege against self-incrimination. So how can state law mandate that in order that you fulfill requirements to have certain rights, that you must incriminate yourself federally? So, interesting examples contrary. If you take a look at the State Board of Equalization here in California, their 2007 memo makes it clear that you do not have to say what you sell in order to participate in the tax system. They allow you to leave that blank because they know you don't want to incriminate yourself. Similarly, the county ID cards that are issued by the County Board of Health, they don't have your name on them, just your photograph and an anonymous number. The reason, again, to protect patient privacy. But what this new 266 constellation of ordinances does is flush patient privacy down the toilet and flush the Fifth Amendment down the toilet. Okay, those are some further comments. Hope you're thinking about this stuff like I am. Talk to you soon.